We will next go to House Bill 2710 and call Representative Huffman, please.
Thank you, Chair Barker, committee members, John Huffman, State Representative for House District 59. And in reference to House Bill 2710, the purpose of this bill is to create some guidelines for the use of UAVs and the information that is gathered by UAVs and supportive enhanced technology, whether it's audio or visual, that can be attached to a UAV. Becky Strauss from Oregon ACLU will further clarify specifics of House Bill 2710. My goal is to set statewide policy guidelines so citizens can have assurance that their right to privacy is intact, that industry and users will be able to move forward with development, with applications to the FAA, and the ultimate benefit from the use of UAVs for everything from agriculture to search and rescue. In my opinion, what we don't want is to do nothing in the legislature and then end up with a patchwork of ordinances and moratoriums across the state, similar to what has happened from Seattle to Virginia. And a patchwork approach will not lend comfort to citizens, the UAV industry, the ultimate users of UAVs, and it will inhibit the expedited use of UAVs for the beneficial activities, like I say, from agriculture to search and rescue. So that gives you kind of a premise of where I'm coming from on the use of UAVs. And you notice I didn't mention drones. Mr. Taylor will quickly tell you, as I do, that the industry is trying to move away from the term drone, and so I'm trying to get in the habit of using UAV or UAS as an unmanned aerial vehicle rather than drones. I'd be happy to answer questions, but I think you're going to have a lot of testimony following me, and I do have a committee that I could get to. So thank you very much.
Thank you very much. David, I have a question. Thank you very much, Representative. Go ahead.
I'm sorry, Mr. Chair, and Representative Huffman. If you'd rather, I gather we'll hear from other proponents. If you'd rather punt, it's no problem at all. Sorry I did not get you this question in advance. First of all, I appreciate what you're doing on this issue. I know that, for example, the Clackamas County Sheriff, which does a lot of the Mount Hood search and rescue, I believe you crafted the bill specifically to accommodate his office. Thank you for that. My issue, just off the top of my head, is that right now, a law enforcement can fly over a property without a warrant and photograph what is down below. They can do it in a helicopter. That's settled law. They can get in a helicopter, fly over, and photograph, for example, a drug grow. If this would, in effect, I believe in this case, if a drone were to do so, it would need a warrant beforehand. It seems like it's taking a cheap, inexpensive tool for law enforcement and taking it off the table. Can you, if you wish, or you can punt, address that? Why should we do that?
There are some attorneys that are going to follow me that can get more precise about current Oregon law,
right,
and how this would affect that. And again, I don't want to get in the way of all the beneficial uses, whether it's for surveillance or agriculture, crop spraying, search and rescue, all the great uses that are out there. Just want to do whatever necessary to create some framework with some sideboards so that whether it's law enforcement or anybody else, they do have a clear understanding of how to use the UAV and or the information that's collected so that the industry can thrive. You know, one of the cautions that I've had to use in this is not to craft something so narrow that it does hurt the industry.
Right.
Because Oregon is definitely a beneficiary. From the Gorge to Central Oregon, I'm flanked on all sides on my district with the drone industry. And so because of the economic development and the job creation, the last thing I want to do is hurt the industry. But I do think that citizens need to have some assurances in how this is used. And, you know, as we've had stakeholder discussions, we've talked about plain view. Has the doctrine of plain view changed as you're not standing on a knoll out here surveying with the naked eye anymore, but we do have the ability to attach what I call enhanced technology that can, from several thousand feet up, zone in on something, a gnat's eye on the ground. And so do we need to be looking at that to make sure that people's rights are intact?
Chair, members of the committee, the state of Oregon can regulate public bodies. It cannot regulate in the public airways. And that's approximately 400 feet. There's been a U.S. Supreme Court case and an Oregon Supreme Court case. The Oregon Supreme Court case involved police in a helicopter above 400 feet. They saw a marijuana grow. They then had probable cause for a warrant. The Court of Appeals decided, going back the days of the Roman emperors, actually, that you own to the heavens. And the Oregon Supreme Court said, sorry, you can't. We wouldn't have airplane flight if that were the case. And basically said at above 400 feet, they were in the public domain. They were not trespassing. The inference you draw is that below 400 feet, that would be a trespass. The interesting thing about that is, well, who are you trespassing against? I think you're trespassing against the landowner, not the state of Oregon. So I guess that would be the person that would have the cause of action. And I say, generally speaking, 400 feet, because if you live just beyond the runway of an airport, there's rights of way there that are below 400 feet. If you own a building in downtown Portland, I think you would say that a skyscraper, that you own above 400 feet. I mean, that makes sense. So it's a interesting legal issue involved here too.
Mr. Chair, I find it interesting, that you've just described that, Bill. I can't help but wonder about exigent circumstances at all, given this device too and being used. I mean, how that applies. So.
And Mr. Chair, there will be testimony on exigent circumstances by the professionals.
Thank you very much
Mr.
for
Chair.
your testimony, Representative.
In front of you, and what I'd like to do is just sort of briefly touch on my understanding of the constitutional legal landscape and then talk about the details of the bill. Representative Huffman and a bit from Mr. Taylor started to get into this issue. It's our position that there really isn't a bright line rule from our courts right now, from Oregon courts, in regard to what are the guidelines around aerial surveillance. So in many ways what we're saying here is that it's our opinion the drones are different because they can go different places, because they're less expensive. We are setting ourselves up for more surveillance here in Oregon, and that's different. They can be connected with sensory enhancement technology, many different things that are different from, say, a helicopter, different from what our courts do say about someone viewing something with the naked eye. This is different. And so our Oregon courts have talked about what that difference means. They allude to a difference between, for example, an officer up in a helicopter viewing a field with their naked eye. That doesn't require a warrant. It's not a constitutional search. But our Oregon courts have then further said, and I believe I cite the case in my testimony, that when we're talking about what's their term, advanced sensory enhancement, it starts to get into the area of now we're conducting a search. And I say that term search for constitutional purposes, where it would require a probable cause warrant to conduct that search. And so admittedly, we don't know what a court would say about drones right now. And what we're asking the legislature to do this session is say, drones are different. That is rising to the level of advanced sensory enhancement. I mean, these drones have the capability of matching with night vision or facial recognition, all sorts of biometric matching that we could only really imagine right now. And so it's different. And so we'd like to say that our law enforcement agencies, when they use a drone for surveillance purposes, should get a probable cause warrant. Of course, it's not saying that they can't use it. We're not going down the road of Seattle or Virginia that's putting an all-out moratorium or ban on use of drones, but saying this is a reasonable way to approach it, and we're looking to you to state that principle and put in place guidelines around that use. So I hope that helps to set up a little bit of the legal landscape, and I don't think that we purport to say that this bill is codifying law. It's not. The courts are unclear, and what we'd like you to do is take the step and say it's important for us to have these protections when our law enforcement agencies use drones. And so I'll just sort of walk through briefly 2710 with the -1 amendment and give you a sense of the proposal that we're putting forth, and certainly open to making changes at this point to the extent that there still is time. So most of the operative provisions are included in Section 1 of the bill, and so it's hard to really identify, but I've just sort of lined them out by subsection in Section 1. So number 1 is just definition section that's defining drones, law enforcement agency, and public body. And then subsection 2 is this warrant requirement, saying that when a law enforcement agency is going to use a drone for the purpose of surveillance of a person, that law enforcement agency must obtain a probable cause warrant to use the drone for that purpose. And then, of course, imports, and I think that what's listed here is not meant to supersede any other exigent circumstances that already are permitted under warrant law under the Oregon Constitution, but there is an explicit exception in this bill for use when there's an emergency that would risk serious physical harm to an individual, and would just say that when a law enforcement agency is going to use a drone in an emergency, they don't need to get a warrant, they just need to document that they use the drone in that instance, so there's a bit of a paper trail for that use. Similarly, if the law enforcement agency is going to use the drone for the purpose of intercepting communications, that they follow our current statutory law in regard to wiretapping and body wires. Number 4 directs law enforcement to limit the collection only to the target. So if you have a probable cause warrant, anything outside the scope of that warrant cannot be further used or collected. Similarly, number 5, when a law enforcement uses drones, as permitted by law, that the footage must be destroyed within 30 days unless the footage is needed for an ongoing criminal proceeding. Again, this is all sort of getting at the idea that Oregonians shouldn't sacrifice any of their privacy or constitutional rights as we move forward with new ways of surveying people. And so there are safeguards in place to make sure that we're only targeting, surveying those with probable cause, those with which we have probable cause to believe they're committing a crime, and that we're not engaging in surveillance of innocent people. And number 6, I actually learned semi-recently that there are some capabilities or some interest from agencies outside of Oregon to be putting tasers on drones. This bill would prevent that, saying that law enforcement agencies may not use any drone that has the capability of being weaponized. Number 7 is an effort to put in some public oversight over the law enforcement agency's use of drones, saying that public bodies, and it could be the case of a law enforcement agency that begins to use drones, must have a policy in place as to when they're going to use them. Law number 8, public bodies or law enforcement agencies using these drones must comply with FAA requirements. I think that's a little bit of where Mr. Taylor was going with the reference to the 400 feet and whose airspace is whose. And then under number 8, the bill would also require that local governments approve the use of drones for any of their local bodies. So, for example, if the Portland Police decided that they wanted to begin using drones, not only would they have to put policies in place, but they would have to get approval from Portland City Council to do that. And then finally, the intent behind the -1 is to try to get at some of the what-ifs. I think there's a bunch that we don't know about how law enforcement agencies might want to be using drones, and as Representative Huffman mentioned, the objective really isn't to tie the hands of industry or even law enforcement when it comes to quote-unquote legitimate uses of drones. For example, search and rescue is a great example, or land mapping, I've heard, might be a potential use, even reconstruction of accident scenes. Most of those generally seem okay, and the principle behind the -1 is that when a law enforcement agency is, or a public body is using drones for a non-law enforcement purpose, that it not be used kind of as a backdoor to circumvent the warrant requirement that's in place. So it would say that the footage captured for the non-law enforcement use may not then later be used for the law enforcement use. In conversations with some of the law enforcement stakeholders, there's been an additional what if, okay, you're out there doing search and rescue and you witness something with the drone that you feel like you may want to use later for a law enforcement purpose. I think we're open to that conversation and might explore ways to put in maybe a warrant requirement for that use, so that you still have to go to a judge and demonstrate that you need the footage, but it's not, as I said before, really just a backdoor for warrantless searches. So that's the bill. Happy to talk about it or answer any questions. Thank you.
Thank you. One of the things, I don't know if we talked about that, but I've talked to others, the possibility of, I have a warrant to follow Bill Taylor. Bill Taylor suddenly meets up with Representative Hicks, and they hold up a store, and Hicks shoots somebody. We have that on tape, and the way this is written, and we could not use that film of the other person. So that I think that piece needs to be corrected.
Chair Barker, members of the committee, I agree. I don't think that the objective is to tie the hands of law enforcement, just figuring out how to work out those details.
We're going to need, I believe we'll need a different amendment than to make that work. Mr. Taylor?
Members of the committee, Strauss, what about the issue of exigent circumstances, so that the police is unable to get a warrant? They know a crime is about to be committed, but they can't get a warrant because time makes it impossible to do so.
Chair Barker, Counsel Taylor, members of the committee, my understanding is that that's embodied, it's kind of implicit in a warrant requirement, is that when you put in a warrant requirement that constitutionally there are circumstances where that warrant requirement would not attach. So destruction of evidence or imminent harm to someone, things like that that are established already would apply here. So that if it was a constitutional exception to the warrant requirement, that would not be needed in the instance that you're referencing.
But it's not specific in the bill, is that correct?
Chair Barker, Counsel Taylor, beyond an emergency exception that is in the bill, there's nothing in the bill that says already constitutionally applicable warrant exceptions apply here. It may be, and I'm certainly open to that language, it might seem superfluous to me. Thank you.
Representative Hicks.
Yeah, and to run with that a little more, I mean, would it serve any purpose really to put that in there? Because that's almost like saying, and this bill is constitutional.
All right.
Because it's language used by the court for that. So I don't know if exigency would really change anything. Would it?
Chair Barker, Representative Hicks, I think that I'm in agreement with you. I'm happy to be challenged on it, but I think that's correct.
Yeah. Thank you.
Representative Barton.
Thank you, Mr. Chair. And actually, again, building on the same level of questioning, I'm sorry to harass you this way. It's kind of interesting. I hope you find it sort of fun. But similarly, I mean, when this legislature creates a statutory requirement for a warrant, that's not necessarily constitutional. Similarly, but then the remedies also might not apply. I feel like there's an assumption underneath here that there's an exclusionary rule that applies to a violation of it. But I don't necessarily see why that would be the case. We could require, in theory, public agency get a warrant for anything that is above from the constitutional floor, but I feel like there's a whole host of jurisprudence that doesn't necessarily follow just because that's what this body chooses to do.
Chair Barker, Representative Barton, I'm not positive what question you're asking. Are you?
What would be the remedy to a violation of the warrant requirement in this bill?
Chair Barker, Representative Barton, I think that through the, and this is now I'm kind of treading in waters that I really am not sure, but I'll answer anyway.
We both.
I think that the typical process is that if something is gathered, evidence is gathered kind of in violation of statute or in violation of law, it would be subject to a motion to suppress for that evidence in a criminal trial. And then I believe that there's also further, whether it be case law, that would say that if there is a statutory exclusion in the bill, it's kind of an automatic, this is not allowed in the criminal trial if gathered unlawfully. So there's kind of two pieces there. So I think absent an explicit exclusion, our bill would probably fall under being subject to a motion to suppress that evidence. And I would encourage the committee, as we contemplate other amendments, to think about putting in the statutory exclusion, so it's very clear that if information is collected unlawfully, that evidence could not be used.
Chairman Strauss, that's in your amendment, is it not? Any images or other information acquired through the use of a drone by law enforcement agency not related to the target person, any evidence derived from that information is not admissible.
Oh, thank you, Mr. Quite right.
And not subject to a motion to suppress. Chair Barker, Counsel Taylor, I think the -1 does get at most of that.
Thank you. Thank you, Nick, please.
Thank you. My name is Tim Reeves, and I am the state coordinator for the 10th Amendment Center in Oregon. I'm also a veteran, and as a veteran, I appreciate the role that drones play in warfare, and that they make us able to carry out war with lower casualty. Although I'm anti-war, I do appreciate that Americans aren't dying. However, just like armored personnel carriers make soldiers less likely to die, and drones make other airmen less likely to die, that doesn't mean they should be used in local law enforcement. Here in Oregon, in civilian area, drones should not be militarized, and this bill thankfully makes that clear, that we are not to make militarized drones. And also, another thing about them, and I'm sorry, this is the first time testifying here.
You're doing fine.
Also, I would like to say that just because something is easier to capture by drone doesn't make it preferable to do so. I mean, the easiest way to keep tabs on everything and make sure you see every crime that happens is to put a closed circuit camera in everybody's house, and nobody here, I think, would advocate that. The idea that just because it's easier to gather information, then it should be legal. Well, we live in a free country, and in a free country we don't get treated as criminals until we are proven to be likely criminals. So I really like this bill, and that says a lot because, I'm a libertarian. I usually don't like new laws. So I really am in favor of this, and I hope you pass it, to put some restrictions on what can be done with unmanned aerial vehicles. I do appreciate that it's a big business opportunity. It helps soldiers weather wars easier, and it can help search and rescue, and there's a lot of great applications, but shouldn't be militarized, and Fourth Amendment protections should be defended even though we have drones and enhanced abilities to violate them. And that's all that I have, but any questions I'd be happy to answer.
Thank you. Any questions? Thank you very much.
Chair Barker, members of the committee, with crops, livestock, whatever. So this bill allows that use to continue, and we are happy about, and we support the amendment for our second concern. Farmers are under a lot of regulations that they have to adhere to, and when there is a prospect of having a UAV up in the sky, maybe looking for mapping, search and rescue, whatever, We feel that information should not be shared with other agencies that could then come after them for an easement, for example. There are procedures and policies in place that farmers live under, and we feel that is sufficient. And with the growing use of UAVs, you shouldn't commingle those activities. Having said that, I think the committee has brought up a lot of good points regarding the use for law enforcement and search and rescue, and it sounds like there's a path to get there. I know that this bill does address our concerns, and I would be more than happy to try to answer any questions.
Any questions? Representative Olson.
Thank you, Mr. Chair. Ian, is there any documented incidents right now in Oregon that we're using drones illegally for search and seizure?
Representative Olson, Chair Barker, I have no idea. I don't think so, and that's not where Farm Bureau is coming from. I think a lot of our members, they come from rural Oregon that probably work fairly closely with their search and rescue teams and probably work together on a lot of issues. So I don't know of anything. In fact, I would probably go out on a limb and say, no. I think the genesis of is to make sure that doesn't happen. If you're going to write a law, let's make sure that we can get it right. And move forward.
Right.
Chair Barker, Representative Olson, there are no law enforcement agencies, to my knowledge, using them. The procedural barrier at this point is that they all need to receive a FAA permit to fly them. So we know that at least one law enforcement agency has applied for that permit, and that permit is still pending. And I believe there's another public body in Oregon that's applied. But as Ian mentioned, this is meant to kind of get ahead of things and put in guidelines so that when law enforcement agencies do have drones, that they know how they can use them.
Representative Tomei.
Thank you, Mr. Chair. This is for Becky. Becky, as we were talking about this, it reminded me, I was looking on Google one day, and I could see they went by my house, and my car was there, and they had my license number there. So, I mean, is there any similarity between what you're trying to do here? Are there any restrictions on what Google does with their drive-around cars, whatever they call them? And some of them are unmanned, right? So it seems to me that they can record a lot of information on the ground that I wasn't aware that they knew that much about me.
Chair Barker, Representative Tomei, I think most generally the interception of new technology and the implications for our privacy rights is highly concerning. I don't know specifically what the guidelines are around Google, simply because they're a private entity, and we have had concerns in the past and continue to have concerns around how law enforcement accesses information collected by Google, for example, which is really a whole different bill and a whole different thing, but obviously very closely connected. And so what we're trying to do here is just take a first bite at the apple and say, we see this new technology coming. We'd like to look at the way that law enforcement agencies, and in some cases more broadly public bodies, use them, but there's certainly a much broader world out there in terms of what's being collected.
Thank you, Mr. Chair.
Chair, members of the committee, one of the intriguing things about this whole area is the federal government does not regulate hobby planes, hobby model airplanes. What's happening with technology is technology is getting to the point where they can mimic many of the things that more sophisticated machines can do. And many hobbycraft people have morphed into doing it for a business. And when they do that, they're now required to have a federal license, which none of them have, because the federal government only last week started to consider licensing people for doing this for a business. As soon as you start using that model plane for a business, you are now a UAV. And when you're a UAV, you're required to have a federal license. So I have a feeling we're going to see a lot of people in business without a license in the next few years.
Thank you, panel. Darrell Fuller, Tony Garcia.
Order you wanted
Go
to hear
ahead,
from?
you're fine, any order you'd like.
Okay.
Please remember to identify yourself for the record.
Sure. Chair Barker, members of the committee, my name is Tony Garcia, and I'm here on behalf of the Oregon Military Department. I'm also a captain and a judge advocate with the Oregon National Guard. A few things I wanted to mention for the record is first that the Oregon Military Department is already regulated by the Department of Defense and the FAA in regards to unmanned aerial vehicles or drones, as we may call them. We also conduct operations in this state, and those are conducted not only by the Oregon National Guard, but we have Washington National Guard, California National Guard. About 2 weeks ago, we had Washington National Guard Special Forces conducting operations in Central Oregon. We also have a number of active duty components that also conduct operations here, and this bill would apply to them. Now, in this bill, it mentions that it covers any body that prosecutes offenses. And most of the testimony here today has been about a law enforcement agency. But the military also prosecutes offenses, both on the active duty side with the Uniform Code of Military Justice, and even here in Oregon where we have the Oregon Code of Military Justice. So what we would like to see is an exemption from this bill so that we may conduct our operations, which is similar to what we have going on the Senate side. Also, in addition, when looking at the emergency provision in here, the emergency provision looks limited to me in that it is limited to a risk of physical harm of an individual or the life. But it doesn't expand to a declared state of emergency by either the governor or the president. And we can envision many circumstances where we might be called upon for search and rescue, not necessarily for a person, but for property or to help a particular area after there is no risk to life, and we would need to be able to conduct those operations. In addition, the Oregon Military Department does interact with the business community, and we would want an exemption because research and development may be going on in the state. We wouldn't want to be prohibited from what we're doing and working with the business community on unmanned aerial vehicles. And subject to your questions, that concludes my testimony. Thank you.
Any questions? Thank you.
Mr. Chair, members of the committee, Darrell Fuller on behalf of the Oregon State Sheriff's Association. We appreciate the work that's being done on both sides, trying to find something that will sort of put some side rails on the use of drones in the state of Oregon. From the perspective of the sheriffs, we're looking for as broad authority as we can get initially, and perhaps narrowing that as time goes, as opposed to looking at the narrowest possible authority and looking to expand it in the future. Give you an example in the -1 amendments. It says, and the chair used an example that's similar to one that I've used. If we have a warrant on somebody and we're using an unmanned vehicle to surveil somebody under a warrant, and another crime occurs not dealing with that particular subject, this bill prohibits us from using that information, and we would prefer that if a drone is being used for a legitimate law enforcement purpose, that any information collected during that operation would be available to us in a criminal prosecution. Similarly, if we were using a drone for search and rescue, and we were crossing over both state and private lands, it was a legitimate use of the drone because we are actually out looking for somebody. It's not just out surveilling. And we were to come across the crime scene, but we didn't have a warrant because we're doing a search and rescue, we would want to be able to take action on that crime scene. And so our preference would be amendments that expands the use of drones to the greatest extent possible rather than narrowly casting it as much as possible. As the example that the chair used was exactly the kind of example I used, where you catch something you don't. This body is looking at a bill similar to this. It has to do with photo red light cameras. Right now you can only use it to give somebody a ticket for running a red light, where law enforcement, in some cases the people running that red light are running away from a crime, and they would like to be able to use that photo that places a suspect at a time and a location, perhaps close to a crime scene. But right now they couldn't use that photo in a criminal matter because they could only use it to issue citation for running a red light. And so we view this similarly. We would appreciate the legislature looking at amendments that would expand the authority. I'd be happy to answer any questions you have.
Thank you. Mr. White.
Chair Barker, Vice Chair Krieger, my name is Bill Hoyt. For the record, I'm the legislative chair for the Oregon Cattlemen's Association, immediate past president, fifth-generation rancher. We have some issues with how the bill is interpreted by non-law enforcement agencies. For instance, if you're being prosecuted, it's pretty clear what they could do, what law enforcement could do on other prosecutions. But it's not very clear on what could be done by agencies not involved in law enforcement. So, for instance, DEQ or EPA or other agencies that may use the data, how long could they use it? We see that it's only 30 days, but in that 30-day period, what could be done? Could they create a scenario by which if they got this information, then they could develop a case, and then that 30-day period would be eliminated and it could be carried on? We're concerned about private property rights. Our organization is a very staunch believer in private property rights, and we think that this bill, although we haven't taken an official position on it, has some areas that still need to be researched in how they might impact private property in terms of other agencies besides law enforcement. And we see what the bill is intended to do, but we think there's some unintended consequences that could be used by other agencies away from law enforcement. And I'll take questions.
Are there any questions? Thank you. And it's again, we're going into technology that we don't really know too much about yet. And somebody in my office was saying this is kind of like computers. You know, if you looked at computers 15 years ago and then today, and so things are changing rapidly, and we're kind of chasing the horse right now. So thank you very much. Those are important issues that we don't normally. Everybody just thinks.
Well, I just want to kind of expound on what you just said, Mr. Chair. I mean, yeah, as technology, I'm not familiar with, and as a result, I'm kind of thinking I'm not sure whether we need that bill right now. But point being is, I was doing some research, and I see back in 1981 or 82, you had Campbell versus State of Oregon, where you had two counties, Washington and Columbia, and you had a suspect that had committed multiple burglaries between the two counties. And so a radio device was placed on the suspect's vehicle to proceed with that. Later in 84, the Supreme Court ruled that was unlawful search. Then you have Kylo back in 2001, and that happens to do with photo imaging. And I thought that was rather interesting when that first, because you had a law enforcement agency looking through walls of a house to see whether there was marijuana grow going on in there. And, the Supreme Court ruled that was illegal search, too. I just don't feel like we're there yet, just like what you're saying right now with this technology.
Thank you very much.
Next to Darrell Fuller, and it may have looked like who he was representing.
Okay. I see you there now. Faint. You must not have pressed down. Sorry.
Thank you, Chair Barker, and members of the committee. For the record, I'm Kevin Campbell, Executive Director of the Oregon Association of Chiefs of Police. I've sent you all my testimony, so I do not want to spend a lot of time going into detail. I do want to mention that we do acknowledge Representative Huffman's hard work and Becky Strauss to try to get us at the table to try to work something out. We still continue to have some concerns, and I'd like to mention a few of them. Darrell Fuller already has gone into some of them, but I do like the idea of creating some law that prohibits the kind of patchwork of laws we might see on the local level that I think are more difficult if that ever happens. I do want to acknowledge that the FAA does have a big say in how this currently operates around the United States, and we know they're going to continue to issue regulations which will have an impact on what we do. So what does the FAA currently say about these unmanned aircrafts? Because it's important to note that when we use the word drones, and I want to also ask that that word be eliminated, it brings up these images of militarized, multi-million-dollar flying systems that can operate for long periods of time remotely. And when you look at the FAA regulations related to what we're talking about today and the potential law enforcement use, let me show you or tell you what the current PL 112-95 FAA guidelines say. Flown under 400 feet, within Class G airspace, in daylight conditions only. So night vision goggles don't, or type of cameras don't necessarily come into play. Within line of sight of the operator and outside of 5 statute miles of airports. These are very limited range tools that we think may have a very positive potential for law enforcement. But let me acknowledge up front that we don't think that any technology gets a pass in terms of the Fourth Amendment and other constitutional protections and just decades of case law regarding privacy rights. And as a law enforcement, someone representing a law enforcement association, we would say that we are sworn to uphold that as well, and that we believe that the courts are perfectly able to take new technologies as they come along and establish what privacy rights should continue to be protected, and we're confident that they will in time. I was talking to Becky a little bit about her challenge compared to the challenge law enforcement has. Her challenge is that technologies are going to continue to come, and privacy is going to continue to be an issue for her. Just like for law enforcement, marijuana continues to be an issue that keeps on coming. Both of us, we may be losing battles, but I want to acknowledge that for law enforcement, privacy rights is a battle that we feel like is very important as well. Drones are different, but so is every other technology that comes down the pike, and I think the courts are well positioned to determine that privacy rights will continue to be fully protected with any new technology. We would use these type of vehicles or aircraft for some very specific purposes, and you've already heard about some of them. We would like to make sure that we don't prohibit the use of what is a very effective use of technology at low cost, because unlike the military system, which are multi-million dollars, these are fairly inexpensive, they're easy to get up in the air, and they can accomplish some very important public safety purposes. You already heard crash scene reconstruction, where you get an aerial view. It can mark everything from skid marks to the alignment of cars after a wreck. This is the kind of use that it can be used for. Actually, in active shooter situations where you have a barricaded subject or you have people in danger, where putting an officer in harm's way compromises their safety and potentially the safety of the public. Search and rescue applications, you've heard about all of that as well. So there are some really exciting opportunities for law enforcement in use of these drones, and let me tell you exactly why it's even more attractive to use a low-cost technology option. And it's not so that law enforcement no longer has to be in the people business, it's the complete opposite. If you looked at the Criminal Justice Commission report in 2008 that talks about our officer per thousand ratio in Oregon, we're the lowest in the nation. And the events over the last couple of years have only decreased our ratio compared to other states. We just have less officers around the state able to do the kind of work that citizens expect. What we really want to do is ensure that our police officers are doing the kind of community policing work that is critical to effective outcomes, reducing recidivism, reducing crime before it occurs, and creating a good community relationship where there's confidence in law enforcement agencies. That's why I don't have a great fear that these type of technologies are going to be misused, because it would violate that principle, the principle of creating good relationships with the public. We'd like to make sure our people resources are effectively used, and that these kind of technologies as they come along are implemented properly and with the right restraints and while protecting privacy. The International Association of Chiefs of Police have already issued some very detailed guidelines for how law enforcement agencies ought to consider utilizing this technology that includes our protection of privacy rights. I'd like to get that to you so that you know that at least law enforcement is thinking about this. What we would do as policing agencies in the state is we'd make sure that our policing agencies were also adopting those policies to make sure we were understanding the proper parameters. We are concerned about the bill simply because of what Representative Olson mentioned before he left, which is this is a moving target and a moving technology. We don't want unwanted or unintended consequences to result. And we also want to make sure that exigencies that are currently available in law wouldn't be circumvented through language that was put in this bill. We're not sure if that is the case at this point, but we certainly want to be careful to avoid that. So with that, Mr. Chair, members of the committee, thank you on this afternoon for taking a few extra minutes to hear from the Oregon Association of Chiefs of Police, and I'd be glad to answer any questions you might have.
Any questions?
Thank you, Mr. Chair. And maybe it's a difference in philosophy around how we deal with ever-changing expectations of privacy and technology. What is the enforcement if we require a warrant and then this body errs on the side of being more protective of individual rights? Where do you see the problem if we take that philosophy and we get out in front of it and we can come back in a year or two and say, wow, that was too much protection in the face of changing technology, we're going to ease up?
Chair Barker and Representative Williamson, it's a good question, and I think I would say that law enforcement would go to get warrants wherever they would now. And so our concern is in creating a more stringent standard that may not be tested and may not take into consideration the way this technology may be used would be taking away a tool potentially before it's even matured. And so we're at the table anxiously wanting to work on this measure to see if we can get it right the first time. And so that's why I haven't come out with we're strongly opposed to this bill, because we want to work to ensure that we navigate this. But I'll tell you, just in the short time, and I never wanted to know this much about this subject matter, just so you know, and now I do, and I'm very sad about that. But the reality is, I feel like I barely have touched the surface of it, and even now, as we've gotten weeks into this discussion, and I know both on the House and the Senate there's been this conversation, I'm just now discovering people who actually have experience, who are actually using the technology, who have been working on a federal level to address this issue federally. And so I can already see where this can get really complicated, and I just want to make sure we don't make a mistake. But it's not because we don't want to cooperate in the protection of privacy of citizens, because I think, as I may have mentioned, that protects law enforcement in a sense. We want to be in a place where we're acknowledging that.
And that's why I say, sorry, Mr. Chair, maybe it's just a difference in philosophy, because where you say law enforcement tools, I would think that preventing abuses is our job. So we may just differ on where the potential pitfalls are around technology.
And Chair Barker and Representative Williamson, I know this will be an issue that's going to continue to plague the legislature for years to come. Yeah. Please count us as a partner in not just using the tools, but also ensuring that the protections are there as well.
Thank you.
Thank you.
Thank you. Representative Krieger.
Chairman, it says law enforcement agency restrictions. Does that apply to federal agencies?
Chair Barker and Representative Krieger, I'm getting a helpful shake from Committee Counsel Bill Taylor, which indicates that the answer might be no.
Mr. Chairman, members of the committee, I don't see how we can make the state law applicable to federal law enforcement, particularly in this area, particularly when you're above 400 feet.
I would say that's probably my biggest concern of their use would be is with the federal government.
Thank you.
No, I mean, I think the military department had a point. We also discussed that as the subset to that question, as because they're a hybrid agency of federal and state. So I don't think that detracts from what the military department told us about their analysis of the bill. But I agree. I mean, the feds, and Mr. Campbell, is there anything at the federal level, statute? Is Congress contemplating anything, anyone anywhere at the federal level looking at regulating these? Is there any precedent going on there?
Chair Barker and Representative Hicks, there are congressional hearings going on, I think even now, regarding this issue, but with the speed that Congress moves, it may not occur for many years.
Thank you very much.
Thank you very much.
Close the public hearing on Bill 2710. Open